Well, hello there, and welcome back to Employment Hour in 30. If it's your first time joining us, welcome. Come on in. Water's warm. We talk about employment law, a lot of stuff you need to know if you work for a living, which the vast majority of us in adulthood probably do. You want to reach out anytime, by the way, during the show or otherwise. 1-855-821-5900, help@employmenthour.com. Lior, coming on the show today, 5 rights often overlooked by employees. These are very important. I guess they're important for both employees and employers, but we're going to focus on the employee for the purpose of this show today. Your emails are coming up and phone calls from our radio show, which you can find as well, employmenthourtv.ca, where you can find a show and listen near you. And we'll play those phone calls back in just a bit. And of course, the all-important severance pay calculator is coming a little later on as well. But you always start with the week that was, something that has been happening on your desk in the office. What's going on?
It's been quite a busy week in the office. A lot of people that have watched this show right here talked to me, called me, emailed me with questions about their workplace situations. And, you know, we have a 30-minute show here, and we cannot cover every topic under the heading of employment law, which is why it's so important to call me or reach out specifically with your specific situation. You may be dealing with an issue that we haven't touched on, or maybe it's a variation of what we're dealing with here, but there's always a solution. It doesn't matter. Just because you haven't heard us talk about it does not mean that your matter doesn't have a solution. There's a solution always. So if you have a workplace problem, your boss did something, said something, you're worried about your security of your employment, maybe you think they're going to let you go, or they have let you go. It's so important to get that advice. We'll give you the ability to contact me, that contact information throughout the show today, so don't hesitate to do that. John, I really enjoy talking to people. I'm not here on TV that often. Most of my time is spent in the office, actually practicing law, talking to people, solving problems. So don't hesitate to reach out to me. About a week there was, where I always like to start a situation that came across my desk just over the past few days, actually from one of our TV watchers, TV viewers. Spoke with a lady who had been off on a disability leave for just under 2 years. And she got that letter from her insurance company saying, when you have your 2-year anniversary on disability, we're going to be cutting you off. Yep. We think you're able to go back to work. Well, that was news to her. She didn't think she could go back to work. Her doctor agreed with her that she could not go back to work. She was still struggling with her medical condition. And just as she's thinking about, how do I deal with the insurance company? What do I do? What do I give them for them not to cut me off? She gets another letter, this time from her employer, saying, well, we expect you to come back to work once you have your 2 years, once you're cut off by the insurance company. And if you don't come back to work, we'll consider you to have resigned. At that point, she says, that's it, enough is enough, and she calls me. And she says, how do I deal with my insurance company? How do I deal with my employer? So let's start with the employer first. As long as your doctor says you cannot work, that's it. Your employer has to allow you time off work. It doesn't matter what the insurance company says. It doesn't matter if there's not even an insurance policy. Some employers don't have insurance policies. If your doctor says you can't work, that's it. And your employer cannot do anything to you. That's not a resignation. That's certainly not a cause or a misconduct. If your employer considers you to have resigned despite what your doctor says, that's a human rights violation. That is a wrongful dismissal. That's illegal. And beyond that, let's talk about the insurance company. The insurance companies are known to very often cut people off before they should be cut off. It happens all the time. That doesn't mean that it's right, not at all. So oftentimes we can either get you reinstated or get you compensation. So don't bother with the appeal process that the insurance company is going to tell you about. It's a waste of time. Call me. I'll connect you with some of my colleagues that deal exclusively with these insurance issues. We'll get that resolved as well. And for employees and employers out there, if you have an employee that's on a disability leave, they can stay on as long as needed if they have the backup of a doctor.
Regardless of whether they're covered by an insurance policy or not, they're two separate things, correct?
Two separate things. One has nothing to do with the other. And the employer should not care whether the employee qualified for disability, did not qualify, whether they're on it or off it. They only care about, is that employee's absence backed up and justified by a doctor? That's it.
EmploymentHourTV.ca is the place to go to find a radio show that's been happening for, I think it was our anniversary very recently, 6 years plus we've been doing that show, really proud of it. And we take a ton of phone calls on all of our radio shows. We farm out some interesting ones we play in the back here, and we talk about them. First call of this show is right now.
I was a manager for 21 years at a place. I had some health issues, and my doctor advised me to take some stress leave. After almost 8 months, the owner of the business said that I was no longer required to come back, and I got walk-in papers. I got 8 weeks severance, but I was there for 21 years,
wow,
managing 2 different businesses. And I'm just wondering, in that situation, is there any recourse?
Wow, you talk about your pennies on the dollar.
pennies on the dollar. But before we even talk about severance, I mean, the fact that he's let go while he's off on a medical leave, that's illegal. His employer says, oh, I don't need you anymore. Well, how does the employer know? He's not ready to come back to work. Maybe by the time he was ready to come back to work, the employer would have needed him. Your employer can't decide that they won't need you in the future when you're not even at work. If they do that, if they say that, clearly what they're really doing is they're terminating you because you're on a medical leave. That's a human rights violation. That's illegal. So right off the bat with this person, that company did something wrong. They breached their obligations under the Human Rights Code by letting him go while he's on medical leave. That's before we even touch about severance. But let's touch about severance now. So he's been there for 21 years, and he was given 8 weeks of pay. Some employees may say, that sounds about right. Yep. Well, it's not right. And how do we know? Well, let's plug the information into severancepaycalculator.com. You can see that on the screen right now. He's been there for 21 years as a manager. I picked an age, let's say he's 59 years old. He was given 8 weeks pay. Severance Calculator correctly assesses him as being owed as much as 24 months pay.
2 years.
2 years pay instead of 8 weeks. And this is a call we got on our radio show. This is not someone that we asked to call. This is someone that was in that situation. And you know what, John? It's not even that unusual. Yeah. When someone is owed 2 years pay and they're offered 2 months pay. So there's a lot of wrong that this employer did. And the good news is this could be easily resolved.
You know, we often refer to as crystal balling the situation. You know, you're off for another 7 months, but I'm letting you go now because I don't need you. They can't do it. They can't crystal ball this situation.
No, that applies in disability leave. It definitely also applies if you're on maternity leave. If you're going to be on maternity leave for the next few months, how can your employer say, I don't need you anymore? Maybe if they're not lying, they don't need you now. But as you said, they can't crystal ball it. They don't know what's going to happen months from now when you're ready to come back to work. So trying to be too proactive on the behalf of the employer is a bad thing and actually could be illegal.
Again, the number 1-855-821-5900 and employmenthourtv.ca to find where you can listen to one of our radio shows. Call number 2 is right now.
I work for a well-known security company, and I was in one position, and they involuntarily shifted me over to another position within the company at a lower rate of pay. I was told this position, it might be going union, might not be. If it goes union, the rate of pay will likely go higher. So I thought, okay, I'll wait it out. Kept asking every so often, any word on the pay going up again? No. And how long should somebody wait? Is there a time frame for that?
And I actually remember this question that we got on our radio show. So this is someone that's obviously being misled. So we're going to give you this other position that comes with less money, but don't worry. That pay is going to go up very soon, and you're going to be caught up, and everything's going to be fine. So he thinks, okay, well, I guess that's fine. I don't want to take a pay cut, but if it's only going to be temporary, I'll take it, and then I'll move back up to what I was before. So he may think that's okay. But when that doesn't happen, he doesn't have to continue working. He's been misled. He can treat that at that point as a constructive dismissal. Now, he can't wait too long. Right? He can't, because if he's waiting too long, he's going to be considered to have accepted this change. So once it becomes clear that the company is misleading him, that they're not increasing the pay, he has to act on it. So he can give them the benefit of the doubt for a few weeks, maybe even a couple of months. But if the pay doesn't go up, that's a change. He's now making less money. He can treat that as a constructive dismissal and leave with severance. And of course, for you watching us right now, if your job has changed, your compensation has changed, your work location has changed, you don't have to accept that. You can treat that as a constructive dismissal, get your severance. But remember, you do have a small window to do that. If you continue working for too long, you would have accepted these changes, and then you're stuck.
Outside of that, he did mention something else about possibly becoming unionized. How would that affect him?
Well, if he becomes unionized, just the act of becoming unionized could be a constructive dismissal.
Wow.
So if you're in a position that's non-union, and all of a sudden a union comes in, and now you're a unionized employee, that's a big deal. That's a big change to the terms of your employment. So that alone may allow you to treat that as a constructive dismissal.
He could do that. I didn't know you could do that. I thought you just had to accept it, start paying your union dues and move on.
If you want to continue working, you have to. Of course, you don't have a choice. But you may be able to say, I'm not going to work here. I'm going to leave, and I'm going to make the company pay me my severance because the terms of my employment have been changed.
Help@employmentlawyer.ca is the email to reach out and contact Lior, a member of his team for that matter. As I mentioned off the top of the show, we're going to get into this. 5 rights often overlooked by employees, right? There's hundreds, but we got it down to 5, right?
The biggest 5, the most common 5s, things that employees don't realize, rights that they don't realize they have, and rights that employers may not realize that employees have. These are rights that are overlooked, that are misunderstood, and we want to talk about them here today to make sure that everyone knows what their rights are.
All or some of these are guaranteed to open your eyes. First one is the right to full severance pay upon termination.
Biggest one, the reason behind this show, frankly, is the misconception that you don't get a certain amount of severance, or that the right is overlooked in terms of how much severance you're actually owed. People don't necessarily know how much. It sometimes can be confusing to find out how much. Misconceptions are plenty. A week per year, 2 weeks per year, 2 days per year. I've heard it all. None of that is true. It's all wrong. It's based on age, position, length of employment. Go to severancepaycalculator.com. You can check that out right now if you want. We'll talk about it more later. Big right that's overlooked. And if you do overlook that right, you'll find out once it's too late that you could have been owed another $50,000 in severance. Don't let that happen to you.
Call, don't go to the Ministry of Labor when it comes to severance, right?
You cannot, should not when it comes to losing your job. Cannot help you if you lose your job, can help you overtime, can help you unpaid wages, vacation pay. Not if you lose your job. For that, you go to severancepaycalculator.com. You speak with an employment lawyer like myself. That's all you can do.
5 rights often overlooked by employees. Number 2, the right to a workplace free of harassment. In this climate or any other, it's always been that way.
Probably one of the most fundamental rights that an employee has, one of the most overlooked rights, is the fact that we have a right to work in a supportive and a harassment-free work environment. Very, very clear right. The law imposes that obligation. No employment agreement may necessarily use those words. You have the right to be harassment-free. But the law imposes that obligation, which means if you're working in a work environment that's now full of harassment, that's poisoned, where you're being mistreated, well, that's now become illegal because that right that you have has been violated. So the law provides you remedies. You could treat that as a constructive dismissal. There could be human rights issues. Your employer has the legal obligation to solve that problem if you give them that opportunity. So remember, you shouldn't have to suffer through poison work environment. You shouldn't have to suffer through harassment. Right that you have, whether you realize it or not, is to work in a healthy and a harassment-free work environment.
And is it not a rather large umbrella under harassment? It doesn't have to be sexual harassment, which what always comes to the fore when people talk about this topic, but it can be simple bullying, it can be mistreated by your boss or other employees, right?
Most harassment, in fact, has nothing to do with sex, and it's not sexual harassment. It's someone mistreating them, someone being a bit of a jerk,
right.
Or someone just being a bully and aggressive. That may have nothing to do with sexual harassment. That is very common, and it's still illegal. Even if it's not sexual harassment, you have a right not to have to suffer through that, and your employer has the obligation to deal with that and to fix the problem.
The 5 rights overlooked by most employees. Number 3 is this one, the right to your same job once you return from either maternity, paternity, or parental leave. Right?
Yes. So if you're a parent taking a parental leave, you have a right to the same job. Not a similar job, not kind of the same job with the same pay. And it doesn't matter if the company has hired someone in the meantime. Too bad. They have to make way and make room for you to come back to work. Not only do you have a right to the same job, also the same pay. And if the pay for the job has increased since you've been off, you have a right to that increased rate of pay. So let's say when you were off, you were getting paid $18 an hour, but since then that position pays $20 an hour, then they have to pay you $20 an hour, even though you haven't been there for the last year, let's say. Same job, anything less than that is unacceptable. Violation of the Employment Standards Act, the Human Rights Code. If your employer won't take you back or will try to take you back to a different job, you really got to get on the phone and call me.
If they've blown out the whole department that you're in and you're not the only one who got let go, even though you're on a parental leave, is that maybe one caveat to that rule?
It is. If you're let go because of something that has nothing to do with your parental leave, the company shut down, the department shut down, they lost all their clients, whatever it is, something big has happened that has nothing to do with your parental leave, then yes, the company does have the ability to terminate. They would still have to pay full severance, mind you, but at least it wouldn't be a human rights violation. Right. But those, in my experience, John, are quite rare.
We'll get through these. Number 4, the 5 rights often overlooked by employees. That is a right to refuse a new employment contract, or I guess an employment contract if you've never had one, from your current employer, right?
Current employer is the key phrase here. If you're already working, your employer wants you to sign a new agreement, you can, and I would say you should say no. I'm not going to do that. And the reason you don't want to do that is because there's a reason your employer is asking you to sign an employment agreement, and it's not to make things better for you. It's because it's better for the employer. You don't have to sign an employment agreement, whether you've signed one to begin with or not, haven't signed one. You may never have signed one at all, and your employer wants you to sign one, and they may say, oh, we want to have everyone with the same agreement. You can absolutely say no. You cannot be made to sign. You cannot be punished. You cannot be terminated for cause for not signing it. And if you want to know what it says, what it means, whether you should be concerned about that new agreement, you probably should be. But if you want to be sure, call me. Let me take a look at it. Let me tell you what it means, and we can talk whether it makes sense to sign or not.
The last one of our 5 rights overlooked by most employees is this one. That is the right to be accommodated at work if you have either a disability or an illness, for that matter, right?
One of the most basic rights that we all have is that that is to be accommodated. And let's face it, sometimes life throws a curveball at us. We may have a medical condition we're dealing with. Maybe it's an illness. Maybe we've been through an accident, and we still can work. We just need some help from our employer. Maybe we need modified duties, modified hours, and it's not up to the employer to decide. That's where the misconception is. A lot of people believe that the employer gets to decide if they can accommodate. No, not really. Accommodation has to be given unless it's so difficult and so outrageous that the employer can say, no, I don't have to go that far.
That's
but it's rare. It's rare and it's difficult, and most employers pull or refuse to pull the trigger and back away from accommodation before they should. You should be accommodated. If your employer won't accommodate you, make sure that they know what the accommodation is that you need. Provide them something from a doctor, and if they still won't do it, that's when you reach out to me.
Why a temporary layoff is a termination, that and the severance pay calculator and more, all coming up here. 1-855-821-5900 at help@employmentlawyer.ca through email. Lots more Employment Hour in 30 is on the way. Stick around.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Yeah, welcome back to Employment Hour in 30. To reach out anytime, 1-855-821-5900 would be the number, or severancepaycalculator.com. Over 500,000 people have been through this, tried it out, either used it with some benefit or just wanted to know what they would be owed in the eventuality that they were let go by their employer. Severancepaycalculator.com. Tell me about it.
Well, I said before the break that the reason behind this show and our radio shows 6+ years ago was this idea of severance, and the idea that people were always accepting severance less than what they're actually owed, and would find out when it's too late that that's it, they can't do anything about it. So I wanted to do something about it, and the easiest way that I could think of to deal with this issue is to give people access to that information, to allow them to find out on their own time, how much severance the law says they should have, because it's not a week per year. It's not 2 weeks per year. So I created severancepaycalculator.com. Again, severancepaycalculator.com. And once you go there on your phone, on your tablet, on your desktop, whatever your preference is, you'll be asked a few questions. Your age, your position, and the length of your employment, not your name, not the company's name, that doesn't matter, and that's it. Once you've input that information, you'll find out how much severance you're actually owed, the real amount. It's anonymous, it's free, it's easy to use, takes seconds to do it. No issues there whatsoever in terms of using it. And you don't have to just use it if you've actually been let go. In some situations, you want to be prepared. You think maybe something's happened. I think there's restructuring coming. I want to know what I would be owed. In some cases, this is a bit more problematic. You want to find out if the severance offer that you've accepted in the past was good enough. Yeah. Be careful if you do that. You may realize,
don't cry.
That it wasn't. It probably wasn't. But severancepaycalculator.com, the very first place you go to if you lose your job. You don't believe me that it works? Try it right now.
You know, it's interesting, too, because until you created this calculator, somebody would have to phone employment. Oh, I don't want to bother doing that. I'll just take my offer. Wow. No. Losing tens of thousands thousands of dollars. So this is an amazing tool. You saved people a lot of money, made them a lot of money, really.
And I think our regular viewers know about it now, but I want you to tell people about it as well, because you may have your friend down the road or your family member that loses their job, and they're struggling with it as well. They want to know how much they're owed. They have to know how much they're owed. Tell them to go to severancepaycalculator.com. They'll be glad, and you'll be glad that they did.
Get to an example right here. After only 10 months on the job, Anne was let go during a quick meeting with her boss and an HR representative. That's how it works. No reason was given. She has 3 days, count them, to accept a 2-week severance offer. Anne's 57 and had a $60,000 salary in a professional role on top of that.
So if we were to walk outside the studio right now and ask 10 people what you should be getting after 10 months of employment, or if we ask them, is 2 weeks of severance good enough after 10 months of employment?
Oh, yeah.
I bet you 9 out of those 10 will say, oh, yeah, she's only been there for 10 months. 2 weeks is fabulous.
Right.
I bet you most people would say that. Well, guess what? It's not only is it not fabulous, it's not even close to being enough. She's owed much more. Remember the rule that short service employees are treated even better or disproportionately better than long service employees. So rather than me just tell you how much she's owed, let's actually plug it into severancepaycalculator.com and let's see how much she's owed. Okay, so Anne worked for 10 months as a professional, 57 years old, making $60,000, and of course was offered 2-week severance. As you see on the screen, Severance Calculator says that at a minimum, she's owed 3 months' pay and as much as 6 months' pay.
Wow.
Now, John, the difference can be over $20,000 for her. Now, we didn't make up this scenario. We didn't just decide to make up numbers. This is from a real situation that came across my desk just over the past couple of weeks, and that's why the calculator works. Yes, she gets as much as 6 months' pay, as much as 6 months of severance after only working there for 10 months. It's right. It's the law.
It also says she only has 3 days to accept.
So here's how that works. I'm going to offer you 20% of what I should be offering you, and I'm only going to give you 3 days to accept that terrible offer. No, it doesn't work that way. That deadline is meaningless, okay? If I told you I owed you $100, but I'm only going to pay you $20 if you sign this within 3 days, you'll probably tell me, yeah, no thanks, Lior, not going to do that. Same thing here. That deadline is meaningless. Your rights don't expire in 3 days, in 10 days, or in 30 days. You have 2 years to pursue those rights. It's a pressure tactic. Do the smart thing, do the right thing. Go to severancepaycalculator.com or call me. Make sure you get what you're owed.
EmploymentHourTV.ca, as mentioned in our first segment of the show, that's where you go to find a radio show. From it, we take a bunch of phone calls, farm them into this show, and we talk about them. Phone call number 3 is coming up right now.
If an employee comes to me and says that they're going on job interviews, say they saw a very good job that might be a better advancement in their career, does that give me any grounds to let them go?
That's an excellent call.
It's an excellent call, and I remember that call. And this is a call from an employer. So this is an employer has an employee that tells them, just so you know, I'm looking for other work. And most employers are not going to be happy about that. And there's going to be an instinct there, well, I'm going to let you go. If you don't want to work here, then out you go. And that's fine. You can terminate the employee, but it's not a for-cause termination. So even though the employee is looking for work, if you're going to let them go because of that, that is a without-cause termination, which means still you have to pay full severance. The act of looking for another job is not considered misconduct. Now, if they're not doing their job, if they're not showing up for work, if they're slacking off, yes, they may be caused to discipline them. But if they're doing their job, just they also spend time on their off hours looking for other work, it may not make you happy. It wouldn't make me happy, but it's not illegal. So no, you cannot let someone go for cause because they're looking for another job. If you want them gone, by all means, you can let them go with full severance. Anything else, John, is a wrongful dismissal.
Okay, as I mentioned before, why a temporary layoff is a termination. We'll get to that after a short break. 1-855-821-5900 and help at employmentlawyer.ca to reach out through email as well. Lots more Employment Hour in 30 is on the way.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-833-IN-YOUR-CORNER, or go to inyourcorner.ca. You thought you had a secure job. You didn't see it coming. Now what do you do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back to Employment Hour in 30. Scholes here, Lior. We're going to continue on here. Again, it's employmenthourtv.ca to find a phone call, or at least find a radio show that you can listen to. And from that show, we take a ton of phone calls over the last 6+ years. We've been doing that. We'll get to another call here and we'll comment on it.
My friend, he doesn't know much English, so he works here for 22 years, and company got slow, and they laid him off. This is about before Christmas. They laid him off. They promised they will call him back. They never call him back, and I just want to know what's his option.
Yeah, they laid him off, all right.
Well, yeah, they laid him off. That is a termination. Remember the rule, and our regular viewers, I think, know this by now, that if you've been laid off supposedly temporarily, that is a termination in the eyes of the law. An employer does not have a right to do that. So just because you've been laid off temporarily doesn't mean that you have to sit at home waiting for the company to call you back. So in this situation, even if the company meant to call him back, he still has the ability to treat that as a termination. Definitely if they're giving him the runaround and not calling him back. So what does he do? He says, I'm out of here, and he pursues severance. Let's find out quickly how much severance he's owed. Again, we know where we go for that, severancepaycalculator.com. So he's in a labor type of a role, 22 years of service. I picked an age, let's say he's in his 50s. And obviously he wasn't offered any severance, but he's owed as much as 22 months of pay. 18 to 22 months of severance is what he's owed, even though his employer hasn't flat out terminated his employment, even though they've only laid him off temporarily. And that's very important to remember. If you've been laid off temporarily, especially if this is the first time that that's happened, you can treat that as a termination, pursue your severance, and not have to sit at home, fingers crossed, that you'll be called back to work.
And 22 months is great, especially when it says, it was just before Christmas. Thank you very much. Right before Christmas.
Merry Christmas. Right? Unbelievable. Yes, it's not a very nice thing to do. Probably best to leave, get your severance, move on.
You got it. Terminationquestions.com is another resource for you to ask questions about the show, about your employment. We'll get to one from there. I'll read it out. I know you want to comment on this, Lior. I think we got time for this one. It says, when I was hired 7 years ago, I signed an employment agreement that said I was a contractor. No taxes are taken from my pay, and I work on a fixed schedule. Others have lost their jobs recently and received 2 weeks' pay. Count them, 2 weeks' pay. Would I get the same amount if I was to be fired?
No, you're not going to get the same amount. You're going to get a heck of a lot more. Yeah. And if you work somewhere for 7 years, that's it. I'm done right there. I'm telling you right there, you're not a contractor. You are an employee. No one as a contractor really works for 7 years, especially though if you have fixed pay and you fixed schedule. You are an employee in the eyes of the law. So he's been misclassified. Okay, this person has been misclassified as a contractor when he's really as an employee. That means a bunch of things. It means that he could actually right now be getting overtime and vacation pay and holiday pay. But beyond that, if they are going to let him go, he's going to get severance like an employee. He has to get severance like an employee. And that's not 2 weeks. So after 7 years, again, depending on his age and position, it could be 8 months, 9 months, 10 months of pay. Months, not weeks. And his colleagues there in the same situation, they could have probably done the same thing. Very common. Employees get misclassified often, wrong, you're owed full severance.
And this is also a warning to both, I guess, employer and employee, because no taxes are taken. CRA is going to have a big problem with that.
If you're ever audited or the company's audited, right, CRA is not going to be happy about that. It makes sense for both company and individual to call a spade a spade. If you're an employee, then you should be treated as an employee. Don't try to get away with something that misclassifies you. There could be tax consequences there. Not a good idea. And so it's not even just about employment law. It's not just about workplace rights. You don't want that trouble. So remember, if you're working as a regular job, steady job, you get a fixed pay, you go to the company's offices, you come home, you go back the next day, do the same thing. You are an employee. It's as simple as that. Anything less is wrong. It's illegal.
Lots of good stuff on the show today. You want to contact now that we are done, 1-855-821-5900. You also have the option of help at employmentlawyer.ca. That is an email. Terminationquestions.com, from which I just read. And of course, the place to find our radio shows and information about the show, employmenthourtv.ca. And always, 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 first place you go, severancepaycalculator.com. If only for interest's sake, that is the tool you want to use. It is free and it's great. Severancepaycalculator.com. We'll catch you next time on Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.